Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, March 26, 2026. We have 11 bills on the docket today, and we are going to start off with House Bill 194 with Delegate Metzger. Delegate Metzger, welcome.
Good afternoon. What a treat, what a joy it is for me to be over here today to present House Bill 194, Incarcerated Individual Apprenticeship Pilot Program, the 26th day of March. Good afternoon again, ladies and gentlemen, Mr. Chair, Mr. Vice Chair, distinguished members. Well, let me see how distinguished you are. Yeah. Again, I thank you for the opportunity to speak to you today. For the record, I'm Delegate Rick Metzger from Legislative District 6 in Baltimore County. I'm the sponsor of House Bill 194. The synopsis of this bill is very simple. While serving their time for the offices of the inmates, they learn a trade, and they get certified, licensed in the trade. I've always been a proponent of the trades, teaching trades, because they're not really no longer in our schools. There's always going to be a need for carpenters, electricians, skilled plumbers, and mechanics, and so forth. But when they finish their sentence, they leave with a marketable skill and a certification. This gives them an opportunity to turn their lives around in society. By the way, this bill passed in the House with bipartisan, and it did very well. And for those reasons, I will share this with you as well. What I like about this bill, ladies and gentlemen, is that when the person is behind the walls and they're, instead of playing video games and watching TV, they actually are going out with this is a pilot program in Baltimore City. I've been working about 4 years, Mr. Chair, on putting this together. And while they're there, they will be going out and they'll be trained by certified plumbers, electricians, and so forth. They'll be given the opportunity of what trade they want to take up. For an example, if they want to be an electrician, it takes a year. Plumbers, the same forth. But what's good about it is they will get paid because Department of Public Works needs people to work anyhow. So there's no physical note with this. And the great part about it is when they are behind the walls, they're getting a paycheck. And while they're getting a paycheck, they're getting a checking account. While they're getting a checking account, if mother is back home or their spouse is back home and is on child support, they will be able to get the court-ordered child support back on track. And then after about a year or two, as long as they're in, they're getting a W-2 form, which means that they can file their income tax. When they can file their income tax, and when they get out of the behind the walls, they can purchase a house because they'll have enough records to buy a home. And so there, ladies and gentlemen, what I'm loving about this, and I took a colleague's advice many years ago, and I never fall in love with a bill. But this bill I have been working so hard with for the past 4 years that I feel like this is really going to take away from recidivism, and it's going to put people back on the real track. I remember the Second Chance Act that we passed about 10 years ago, and this, truthfully, as I've been working on it, puts the icing on the cake and the candle on the top. So I believe it's a really great opportunity for people behind the walls to get out and get a real second chance of life and correctly. And what I love about this, another part, Mr. Chair, is that when they're behind there, when they get their certificate, it's a real apprenticeship certificate. The people that are hiring them will probably hire them when they get out of that. And then what I also like is they can go from there to the Maryland Home Improvement Commission, take a test, and perhaps get their own home improvement license, and then they can start their own business, and what a joy that would be. So I hope and pray that you will give a favorable report back to me. Good afternoon.
Excellent. Thank you very much, Delegate. We have a question from Senator Wesson and Senator Sidnor.
Thank you, Mr. President. Mr. Chair. Too used to talking on the floor here. Delegate, it is a pleasure to have you before this committee. Probably the last time I will be asking you questions. I was looking forward to asking you a tough question, but I love this bill so much. I have no tough questions to ask you at all. I commend you for the bill. It's a terrific bill. I look forward to passing it. Thank you.
Thank you. Good to see you, Senator Muse.
You know, the delegate, when I went back, they said, I got a bill for you, you're gonna love the bill. It's a good bill. The one thing that I want to note, though, just to put on record, and I'm looking at my page 5, lines 7 through 9, and maybe you could tell us what would be the compensation rate for the people?
$15 an hour.
All right. And I just wanted to make certain that that was on record, because I know that there are colleagues that we have who have had some issues regarding some people, incarcerated individuals, and some of the programs we have where they're not getting minimum wage. So I just wanted to make sure we put that one on the record.
I worked very hard with my colleagues across the aisle, and that is the first thing that I said. They will get minimum wage.
Thank you very much.
It's a fair point, especially for what MCE gets paid. Yeah. Senator Love.
Thank you, Mr. Chair.
Thank
Good
you.
afternoon, Delegate. Thanks so much for bringing the bill. You mentioned that there was no fiscal note, but in looking at DPSCS's letter of information, they say that would have a significant impact on the department, totaling over $940,000 in fiscal year 27.
As I was told recently, that's all changed.
That's all changed?
Yes.
Okay,
Yes.
so this is old?
Oh, that's,
Okay.
yeah.
Great, thank you. Thanks.
All right, further questions from the committee? Senator McKay.
Thank you for bringing the bill. I see that the pilot program sunsets in 2029,
Yes.
and the reports do that exact same year. Have you thought about how that's going to work in conjunction? And I didn't know if that was a concern.
Yes. We have determined that through the process, we're going to be taking very close notes to what is taking place so that we can work all the gibbers out and put it together to make sure, because after it sunsets, I want it to go statewide, because I want
That's the purpose of my question, sir.
I want to be successful.
Thank you. Just want to make sure those tracking mechanisms are there.
Yes.
All right, further questions from the committee? All right, seeing none, thank you very much.
Thank you.
Thank you for the bill.
Y'all have a great day. God
You
bless.
too. Tell your son I said hello, by the way.
I sure will.
He's a good man.
He asked about you all the time.
Yeah, he's a future attorney, I hear, so he's a,
He's on the potter's wheel.
yeah. Tell him I said hey, but
I sure
please do. All right, with that, that'll conclude the hearing for House Bill 194. We'll now move on to House Bill 246, which is Delegate Odom. Welcome up. I know you've got a departmental, so welcome.
Thank you, and good afternoon, Chair Smith, members of the committee, Judicial Proceedings Committee. For the record, my name is Richard Jaramillo. I'm Chief Operating Officer with the Maryland Transportation Authority. It's a pleasure to be with you here today. Our Executive Director, Bruce Gardner, wishes he could be here, but he's attending a memorial right now for the FSK with the governor. So I'm here to testify to support of House Bill 246, which would allow MDTA to toll the owners of Class G vehicles, trailers, when the motor vehicle owner cannot be identified through an E-ZPass transponder or license plates read. Currently, MDTA may only toll motor vehicles being defined in statute as a vehicle that is self-propelled and not operated on rails. Many states, including Delaware, North Carolina, and Pennsylvania, do not require front license plates. When those vehicles travel through our facilities, towing trailers that block the rear plate and lack readable transponder, our tolls cannot be collected. The MDTA estimates losing approximately $11 million annually in uncollected revenue from 3+ axle vehicles due to this gap. This bill would assist in recovering that revenue. MDTA intends to toll Class G vehicles only as a last resort, when no plate or transponder can be identified. After hearing stakeholder input, MDTA supported an amendment adopted in the House Environment and Transportation Committee to codify this practice in bill text. If enacted, House Bill 246 would allow Maryland to join states like Kentucky, Ohio, Pennsylvania, and Rhode Island in using trailer plates for tolling when necessary. The legislation has been received the approval from the MDTA board at its December 18th, 2025 meeting. We were intentional in setting an effective date of January 1, 2027, giving MDTA more than 6 months to conduct education and outreach campaigns. Thank you for your time and consideration. I respectfully ask the committee to give House Bill 246 a favorable report and would be glad to answer any questions.
All right, thank you very much. Questions from the committee? Senator James has a question.
Thank you very much. I had a wonderful meeting with someone from MDOT about this bill just a moment ago. They didn't know, and I haven't had a chance to look up about the history. And the history that I'm talking about is I know we have authorized, I think we told by a number of axles. Is that axles? But we also have in there language about and motorized vehicle, right? Mm-hmm. So what I'm trying to figure out, and if you all know, is whether or not it was intentional at all to have both those obligations. And in other words, so a trailer, something you're trailing gets one of them, the axle, but it doesn't have the second requirement, which is motorized. Or whether that was just completely, nobody thought about it, nobody thought it had any kind of problem. You follow the question? Whether they were intentional that they had to be together, or whether it's intentional that they were separated, just so we can understand the policy before and make sure we understand that we're changing a policy or creating a policy or fixing a policy.
Sure. Mr. Chair, Senator, do you understand? Heather Coverly is our director of Easy Pass, and I'm hoping she might be able to answer that question.
My understanding of the history, and we started the tolling process, no one thought motorized vehicle was a single unit. They just said motorized vehicle. They weren't thinking into account for towing and things like that. And so we're looking at saying vehicles are coming through, we can't read a license plate, we don't have a transponder read, so we have to look at the class G, or the trailer portion of the vehicle.
I feel like if it was 100 years ago, I might buy that, but I feel like everybody knew when we were dealing with this creation of all this, we understood that some vehicles are motorized with axles. We understood there were things that have axles that are not motorized and wouldn't be considered, a boat trailer is not something that you're going to go to and get a license for. Mm-hmm. So, I think people may well have understood it, but if you are aware of any legislative history where you can show that it was thoughtless as opposed to intentional, where the people said, yeah, what we're after is motorized, axled vehicles, not axled, unmotorized. Well, I don't know what the word is because we call them trailers, boat ramp, whatever we call those things. To me, they were ubiquitous, they existed, and people certainly knew about them when they were creating how we would be charging for things to be on our highways.
I understand your point.
Yeah.
I've tried to research the history of the orientation of why they use motor vehicles. I've not been able to unearth anything. I will continue to look, and when I find applicable information, I will get back to you.
And in fairness, if we were to do this, we would have to explain to the public that, we are actually expanding what we charge for, which is a tax or a fee, or we are correcting, this was unintentional, should never have happened. The things we pull behind our vehicles also add pressure to our highways that rightfully ought to be captured by some revenue. But people rightfully are going to ask, did you just create new revenue income that was deliberately not done before, or are you correcting something that always should have been captured? And I'd like to be able to answer that honestly.
And I appreciate that, and I will get back to you with an answer.
Thank you.
Thank you.
Senator McKay?
Thank you, Mr. Chair. Can either one of you define for me again Class G trailer vehicle.
Yes, Heather?
Class G vehicles are something that you tow. It could be a boat trailer, landscape trailer. It can be an RV camping trailer, horse trailer. All those are Class G.
Okay.
So they cannot go and travel on their own. They have to be, a motorized vehicle must pull them.
Okay, thank you. Because I know that all 50 states require tractor trailers to have tags on the front and the back, but that's not what we're talking about at all. So therefore, okay.
All right, seeing no further questions, thank you both very much.
Thank you.
Thank you.
With that, that'll conclude the hearing for House Bill 246. Now we're going to go on to Delegate Baylor with House Bill 431.
May it please the court. Thank you. Mr. Chair, members of the best committee in the General Assembly, I'm Delegate Dylan Baylor testifying in support of House Bill 431, which I think is a relatively technical bill. Broadly speaking, the goal of it is to update the statutory requirements for real property recordation. It does three primary things. Firstly, it enables digital submission first of the plats. Current law and the statute has specific reference to Mylar paper, so we get rid of that. Secondly, the bill allows for GPS to be incorporated into the day-to-day activity of surveyors. Right now, it references the terminology is traverse points, which is physical viewpoint locations on parcel. This bill would get rid of that terminology related to traverse points and instead allow for GPS technology. And then thirdly, it just updates some terminology to better align with other parts of the code. It gets rid of the word marsh and instead uses wetlands. I will also add, there was some confusion on the House floor about this, so just to be super clear, the fee, there was originally a fee in the bill as drafted. There is no fee increase in the bill, and there is no opposition. We worked out with MBIA. So with that, I would respectfully request a favorable report.
Excellent. That was my only question, if you would assuage the MBIA's concerns with the $25 fee.
It's gone, yeah.
It's not there anymore. Questions from the committee? All right, seeing none, thank you very much.
Thank you.
All right, with that, that'll conclude the hearing for House Bill 431. We'll now move on to Delegate Chi with House Bill 308.
Thank you. Good afternoon, Mr. Chair and the Vice Chair, and the wonderful members of JPR, and I'm especially thrilled to see my former colleague, Senator Love. For the record, Delegate Lily Chi here presenting HB 308, which is about private mailboxes. HB 308 is a super simple bill that removes a barrier to doing business in Maryland by allowing a business to use a certified mail receiving agency, such as UPS or LegalZoom, as their principal business address to register with ESTED. So they don't have to use their private residence address or have to pay for a physical location in order to register with the state of Maryland. CMRAs are not the same as PO boxes. They are regulated and certified by the U.S. Postal Service and provide back office services to small businesses beyond receiving their mail. And to obtain an address through CMRA, one has to go through a stringent verification process. So this bill simply modernizes our business law to lessen the burden of doing business in Maryland, to encourage more businesses to register with our state. It actually will generate more revenue for our tax coffers and bring Maryland in line with 47 other states. So with that, thank you very much for your consideration.
Nice to have you before us, Delegate.
Good to see you, Senator.
The business law section of the State Bar Association suggested two amendments to the bill, which apparently have not been adopted, were not adopted in the House. One is really simple.
Yep.
It just adds the words "in Maryland" or "in this state," indicating that this drop box, what's it called, the commercial mail receiving agency,
CMR.
must be in Maryland, say not in Ohio.
Right.
I assume that wouldn't be a problem.
Yeah, it's not a problem, but we also don't see the necessity of that because this language they propose is simply clarifying, because if you register with Maryland, you have to have a Maryland address anyway.
Okay.
It will look like a Maryland address, you know.
So, but it's not a problem. The main thing they suggest is deleting section 1-407B. Let me read it. It says, if a person designates an address provided by a commercial mail receiving agency as a principal office for purposes of this article, the person acknowledges that the mail receiving agency shall provide the contact information included in USPS Form 1583 to the department or a law enforcement agency on request. So this was my area of practicing law, so I think I know what I'm talking about. Many corporations use resident agents. And our law firm, in fact, I think I might have been a resident agent for a number of corporations over the years. Our law firm certainly has been. And so the law firm doesn't have any obligation to provide any information to the department or to a law enforcement agency, and they don't do that. What they do is if there's a summons or a letter or something that comes to the resident agent, they forward the letter to the corporation. And that way the corporation is able to preserve its anonymity, which is permitted under Maryland law. So what I'm concerned about this language and what the business law sections is concerned about as well is this would require these commercial mail receiving agencies to be more, to volunteer more information about the corporation in question than the corporation would have to possibly divulge if they used a resident agent. And it strikes me that I love the idea of the commercial mail receiving agencies, but I don't like the idea of making these agencies divulge any information to people who might be interested, including law enforcement agencies, just because there's some USPS form that would require that information to be divulged. The business law section suggests removing that subsection B. Do you have a reaction to that?
I believe what they are suggesting is, I believe what this bill does is actually keeping ourselves in line with what a business would have otherwise have to reveal when they register with ESTED. So I don't think it's out of line with that.
No, actually, when a business registers with, and again, I know something about this is because it's the kind of law I practice. When a business registers with ESTED, all they have to do, they have to provide the name of the business, and they have to provide a resident agent. And the office of the business can be the resident agent's office. So frequently, that's what you do. You say the resident agent is my law firm, Sems, Bowen & Sems, or my name at Sems, Bowen & Sems, and the place of business is Sems, Bowen & Sems. So if anybody wants to serve or sue the company, they serve the resident agent, and the resident agent forwards that to their client who asked them to be the resident agent. So this would provide far more information, and our law firm would never provide to a law enforcement agency, because we have an attorney-client privilege, any information about the client that doesn't have to be divulged. So this would require these receiving agencies to provide more information than a resident agent. And the concern of the business law section is it's going to really weaken the bill, because many businesses will not want to use these receiving agencies for fear that information they don't want to be divulged would be divulged. They will continue to use resident agents.
I understand your concern, and if you want to add some clarifying language as an amendment, I'm open to that.
Okay, great. Thank you very much.
Thank you. Yep.
And just to be clear, this does not get rid of the obligation to have a resident agent, though, does it?
No, it just adds another option for companies that don't have a physical address or don't want to use their personal home address to register with ESTED.
In terms of service of process, how would that work with these things?
So I assume each of us has a campaign, right? Organization. A campaign organization is like a business in a way. So when you go to rent, you can either rent a simple PO box or you can rent a UPS box. When you go to rent a UPS box, they ask for several types of verifications in order to do that. This bill basically allows a UPS type of certified mail receiving agency to be used as the address that you can use to register with
If I'm not
ESTED.
mistaken, with the State Department of Assessment and Taxation,
SDET.
you can't use a P.O. box as a principal.
Well, SDET came up with a guideline. It used to be okay to do that. And then I think it was just last year they came up with a guideline that basically took it out. And they didn't really provide a very good reason when we reached out to them.
It says you can't use a P.O. box now for companies in the state?
No, not P.O. Box. This allows certified mail receiving agency, which is not a P.O. Box.
Thank you.
Yeah.
Thank you, Mr. Chair. Notwithstanding the expertise that we were all treated to, I know you are also very knowledgeable on business matters and a lot of these things. Did the Montgomery County Chamber or the Greater Bethesda Chamber raise any concerns about any section of this bill?
I don't think so. They were very supportive of this. They believe this bill would remove barriers and modernize our business laws.
Great, thank you.
Thank you.
All right, further questions from the committee?
Thank you.
All right, thank you very much, Delegate. Thank you. Good to see you. All right, with that, that'll conclude the hearing for House Bill 306. We'll now go on to Delegate Long with House Bill 426.
Thank you, Mr. Chair, Mr. Vice Chair, distinguished members of the committee. For the record, I am Delegate Jeffrey E. Long, Jr., and I am honored to present to you once again, the third time is the charm, House Bill 426, petition for guardianship of the property of alleged disabled person, stay of civil actions and proceedings. This bill was brought and passed in the House unanimously. I don't believe that this is a partisan issue. This bill would simply offer a critical break to individuals facing financial and housing crisis due to their disabilities by temporarily pausing certain civil proceedings, such as eviction and foreclosure actions. The pause button provides the time for a guardian to be appointed and step in to manage their finances and affairs before a detrimental event occurs. For example, individual A has been diagnosed with dementia, faced the loss of their home due to unpaid taxes despite having the sufficient equity and resources to rectify the situation. Individuals A cognitive impairment prevented them from acting. The absence of a temporary stay led to the lien and loss of their home. Had this provision been in place, a court-appointed guardian could have intervened to safeguard the individual's assets. When someone is truly incapacitated or functionally unable to manage finances, there is a real risk that civil cases keep moving while a family member or another helper is still trying to get legal authority to act. One last example, individual B is living alone with dementia and faced eviction to unpaid rent. Individual B's cognitive condition impaired their ability to do so effectively without intervention. Eviction exposed individual B to harsh realities of homelessness and caused an episode due to instability and unfamiliar surroundings. So HB 426 is the real to-life example. This will protect a vulnerable community. The short window of up to 90 days can mean the difference between stability and chaos. And with that, I urge this committee for a favorable report. Thank you.
Thank you, Delegate, for bringing it.
Yes.
I believe in 2024 and 2025, this came out of the House.
Yes, sir.
Clean with, I don't think anybody voted against it.
No, sir.
Okay. Is there anything changed from those years to this year?
Same bill. Well, I will say that we have added in the 90-day time frame, but however this committee decides to do so, we are amenable. There's been no opposition in the House the past 3 years for this bill.
Excellent. Thank you for bringing the bill, sir.
Thank you, sir.
Thank you very much. May I tell you all that this is one of my best sons in the ministry.
Bless you.
He pastors one of the greatest churches, and I've been happy to have mentored him in spite of his hard-headedness. I've mentored him. I love him more than his being my own son.
Bless you.
I applaud you on whatever you do, and whatever bill you bring here, I will vote no. But besides that, I love you. And you.
See?
No, don't
Mr. Chairman?
Don't tell me it's my fault.
Oh, my goodness.
I was outright lying.
Bless you, Bishop. I love you.
No question.
I was just going to ask if you're as good a minister as the good man beside me that invited us down, but.
When you've seen the Son, you've seen the Father.
Okay, all right, thank you.
Thank you.
Thank you.
Thank you. Thank you.
He's pretty good. All right. House Bill, that'll conclude the hearing for House Bill 420. Man, Delegate Ruff is on his way up, didn't even get called yet. All right, let's see how that goes. All right, that'll conclude the hearing for House Bill 426. We'll now hear from Delegate Embry, House Bill 1020. No, I'm kidding. All right, you're up. House Bill 776. Here we go. Let's rock and roll.
Move favorable? No. Thank you, Mr. Chair, and to this awesome committee. Mr. Vice Chair, thank you all for the opportunity to present House Bill 776, the Nicaila Estrada Memorial Act. I know you all are very familiar with the circumstances that spurned this legislation and the legacy of this legislation that was brought by your former colleague, my forever Senator Jill Carter. Obviously, this is based on Nicaila's unfortunate and tragic death that was caused by a 9-year-old young boy. And unfortunately, there were not enough safeguards in place to ensure that this situation could be approached appropriately. And so the family, in the midst of their pain and their turmoil and their unimaginable grief, they didn't ask for revenge. They asked that we fill the gaps that have been left in the system. And that gap was to ensure that any child under the age of 13 who caused someone's death have a serious look in their lives by our government through the child in need of supervision process before being declared delinquent. And so that's exactly what this bill does. And we're asking for a favorable report so that this family can finally have this bill in Nicaila's honor, because we owe it to her memory and to her legacy to not only provide these wraparound services and a hard look into what is going on in this child's life that would have led them to being involved in an act such as what happened to Nicaila, which you all know, this young 9-year-old child found his grandmother's gun and unfortunately used it against her. We owe it not only to Nicaila, but we also owe it to her family members, Donyette and Balone, who are still here with us today. They've come back again, even though they knew they could not testify, this being a sponsor-only bill. But I want to make sure that we honor them for their advocacy for Nicaila. They have fought for years now to ensure that not only children in this situation get the services they need, but also that families, victim families like theirs, also are able to get services that are provided through the child in need of supervision process. So I won't belabor the point. I think that this bill needs to move forward. I would strongly urge you all to move favorably on it. And I will tell you that the only change that has been made to this bill from previous years is that, and I'll pull this up, right on page 3, at the bottom of page 3 going into 4, instead of having a bifurcated process of either declaring them delinquent or child in need of supervision, this says send them to child in need of supervision, because at the end of the day, delinquency is still a possibility at the end of that process based on the totality of the circumstances that are now analyzed. So I will leave it at that, but I strongly urge you all to move favorably for Senator Carter, for Nicaila, and for her family. So thank you all so much for the opportunity.
Delegate, all joking aside, thank you very much for bringing the bill, and thank you for your work, and thank you to the family. Obviously, we've been coming down here for years, so I appreciate your efforts and just appreciate the presentation today. Questions from the committee? Senator McKay.
Thank you, Delegate, for bringing the bill. Thank you for the, we need to take care of this, without a doubt. According to my former work wife, I need to make sure that this gets fast-tracked on a vote list ASAP. Is that correct, sir?
That is absolutely correct. You've never been more correct, Senator.
Thank you, sir. Thank you. I give full credit to my former work wife.
Amen.
Further questions from the committee? All right, thank you very much.
Thank you, Reverend. Thank you all.
Hey.
Have a great rest of the day.
Hey, thanks, you have a good one. All right, with that, that'll conclude the hearing for House Bill 776. We'll now move on to Delegate Embry with House Bill 1062.
Thank you very much, Chair, Mr. Vice Chair, and all wonderful members of this committee. It's wonderful to be back. So this is a bill I bring to you that has no opposition and no fiscal note. So I just want to lead with that. The genesis of this bill is in 2024, a work group was convened, chaired by a professor at the Carey School of Law, her specialty is medical ethics and healthcare, to look at the problem that hospitals are facing of people who are not capable of making decisions, minors and disabled persons, and who have no representation. And the problem is they're stuck in hospitals, which is not great for their care. And it's also a problem for hospitals who are trying to free up beds and address ER waits and all the other problems they have. The problem is what to do, and what to do that's constrained and not overstepping into their lives. And so the work group is made up, and you have the report as testimony. Professor Hoffman submitted it. Has everyone I think you would want on it. The Hospital Association, disability rights advocates, the judiciary. It's a long list, and they worked, and this is one of the recommendations. And I think it's very narrowly tailored to do just what it needs to do. So there already exists a provision in estates and trusts that allows a judge to order actions by an individual who has been determined to be incapacitated for very certain specific financial transactions. And so this would add to that list that already exists two things. One, the ability to check their financial circumstances, and two, to check their eligibility for Medicaid or other insurance. And the purpose is solely to be able to determine their next step. So to figure out whether they can be admitted into a nursing home, and if so, that nursing home would of course want to know how they're going to pay for it. So that's it. I mean, it's just allowing that. The judiciary also, they were part of this. This is the recommendation that has generated this bill, but also a rule that has passed that mimics this. So there's a court rule in place, but the judiciary does believe that this is necessary too, and have written their support. So we believe, again, that this is narrowly tailored, that it accomplishes only what it needs to accomplish. It doesn't, guardianship is big and long and complicated and invasive. This is not guardianship. This is just limited transaction. It would be under the supervision of a circuit court judge who would determine who the right person is and making sure they have no conflicts, or making sure that they are in the right position to do it. And again, only for very limited purposes. So I hope you will move favorable on this bill, and thank you very much for your time.
I just want to say before you all even think about this, she's my daughter in school. So I need you all to push this bill through, no matter what.
Thank you, Father. Mother, I'm sorry, Father, Mother. Thank you. I appreciate it.
There's so many things going on there. I don't even know where to start. And as a Catholic, I'm confused right now. So. Senator Sidnor has a question.
Is Professor Huffman, is she here?
Who?
Professor Huffman?
Oh, I wish. She tried to sign up, but there was no opposition, so she.
Got you.
I'm sorry. She would love to talk to you, though.
No, she had sent some information in a few nights ago, and I thought I might see it, but thank you.
All right, further questions from the committee? All right, seeing none, thank you very much.
Thank you so much. Thank you all.
All right.
Thank you both.
All right. Delegate Crutchfield is next, and then we'll go to Bagnall. You're up next. So Delegate Crutchfield with House Bill 1144. Welcome.
Well, thank you very much, Mr. Chair, and senators. It's good to see you this afternoon. So I'm here in support of HB 1144. For the record, I'm Delegate Charlotte Crutchfield. I represent Montgomery County's District 19. So this bill is really a simple clarification of the multifamily adjustment for calculation of child support. So what it's really going to be about is to conform with the definition that currently is in Family Law Article 201C-1 with the existing definition that is in Article 12, 201P regarding child or children's overnight stays in the calculation of child support. That is it. I appreciate the time with you, and I respectfully will request a favorable report on this bill.
Excellent. Thank you very much, Delegate. Questions from the committee? Senator West.
Mr. Chair, we got a nice commendation about this bill from Judge Dumais.
Yes, you did.
And on the strength of that, I'll be happy to vote for the bill.
Well, thank you so much. I appreciate it. So I'm the only one you deny. Well, thank you so much.
More than prayers on that one. Oh, my goodness. All right. Senator James?
After what Senator, I said, want to let the delegate know, I'll be voting for the bill on the strength of her name in support, the Delegate Smith.
Thank you very much, Senator.
All right. Further questions from the committee? All right. Thank you very much.
Have a good afternoon.
Thanks. Delegate Bagnall, you're up. Welcome. So with that, that'll conclude the hearing for House Bill 1144. We'll now hear from Delegate Bagnall with House Bill 1292. Welcome to JPR.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the Senate Judicial Proceedings Committee. For the record, I'm Delegate Heather Bagnall, District 33C, Anne Arundel County, here in strong support of House Bill 1292, Child Advocacy Center's continuity of care standards for healthcare professionals and reports of violations. As this committee is aware, child advocacy centers are community-based, child-friendly, trauma-informed organizations that facilitate a multidisciplinary response to child abuse allegations. CACs deliver a best practice model to support children and families throughout the process of investigation, prosecution, and healing. Child advocacy centers provide a safe, child-focused environment where the child's well-being is a priority. And Maryland has 24 child advocacy centers, one in every county in Baltimore City, which provide critical services for some of Maryland's most vulnerable children, children who have experienced abuse or neglect. There is no question that our child advocacy centers do extraordinary work. And this bill is not only an affirmation of that work, but a recognition that the state needs to take a more active role in ensuring that work continues. For over 3 decades, child advocacy centers have been an integral part of Maryland's care network and a crucial tool in fighting child abuse. Now, 3 years ago, this body set out on a journey of understanding when House Bill 1100 was introduced, which would have required child advocacy centers to report annually to the Behavioral Health Administration certain information related to the behavioral health care services provided at CACs, and to issue an annual report, to authorize the Secretary of Health to investigate certain complaints related to child advocacy centers. This bill was the result of an ongoing dispute between a CAC and a behavioral health provider. Now, although that bill did not pass, and ultimately the dispute was resolved through other means, the work to understand the bill identified a more concerning and overarching issue. Despite receiving significant state funding through the Governor's Office of Crime Prevention and Policy, or GOCAP, these centers lacked a specific oversight or accountability mechanism. Now, House Bill 1292 will establish oversight standards for Maryland's child advocacy centers, shoring up the safety net for some of our most vulnerable children. The bill requires GOCAP to collect complaints against the centers, produce an annual report, authorizes GOCAP to refer them to Child Protective Services, and authorizes the Attorney General, if there is a violation determined, authorizes the Attorney General to conduct further review. It streamlines all of the complaints process and responses through GOCAP, aligning the process with the center's funding source. Additionally, the bill applies to individuals employed by the CACs, ensuring that the centers can be held accountable for their staff's actions and must ensure all providers of mental health are licensed or certified by the appropriate health occupations board, providing a meaningful role of oversight to the state of Maryland while holding centers accountable to ensure quality and continuity of care. Working with stakeholders during the 2025 session, the House amended what was previously House Bill 1480 into a posture which passed the House, but ultimately did not pass the Senate. House Bill 1292, as it passed the House, represents additional consensus amendments. So you will see there is no opposition, no fiscal note. And in fact, you'll see letters of support from various stakeholders who were previously opposed to the previous legislation. I am offering one additional consensus amendment, which moves the effective date from July 1, 2026 to July 1, 2027. It was simply missed in the course of moving the bill. It is a consensus amendment, and it will allow CACs that are smaller a bit more time to come into compliance with the best practices and standards that are codified in the bill. House Bill 1292 is an essential step to ensure our most vulnerable children continue to receive the highest standard of care the CACs already maintain, and ensure we are holding ourselves accountable to ensuring our state dollars are meaningfully supporting these individuals. And for these reasons, I ask for a favorable report on House Bill 1292.
Thank you, Mr. Chair. No questions. I just wanted to say welcome, Chair Bagnall. It's wonderful to see you.
Thank you very much. It's wonderful to be in your committee.
Wonderful to have you on our committee. There you go. All right.
Thank you very much, everyone.
Thank you for the bill. Thank you. All right. With that, that'll conclude the hearing for House Bill 1292. We'll now go on to Delegate Wilson with House Bill 1294.
Can I adjust the mic?
Yes.
Thank you.
I was going to say that Delegate Wilson, you got taller and better looking, but
I appreciate that, Chair Smith. Appreciate that, Chair Smith.
Sorry.
I'm all set. Good afternoon. Good afternoon, Chairman Smith, Vice Chair Wallstreicher, and members of the esteemed Judicial Proceedings Committee. My name is Sharon Lanier, and I'll be presenting this bill on behalf of Delegate Wilson. First, I want to make it clear that House Bill 1294 is only addressing the statutory language in the Maryland Code of replacing child pornography with the term child sexual abuse materials, as it better reflects the harm in these practices, as it centers the victim rather than the content. And moreover, the bill is just a modernization bill that aligns the statutory language with the best practices of the law enforcement, prosecutors, as well as the advocates and researchers in this field that protect children from exploitation. And that'll be all. If there's any questions, please let me know. And thank you for the opportunity, and I respectfully urge a favorable report on House Bill 294.
Excellent. Thank you very much. All right, we have a question from Senator James and then Senator Love.
Delegate.
Thank you, Senator Muse. I appreciate that.
Delegate, thank you for bringing this bill. I have been putting in a bill for the last 3 years that deals with child pornography, and unfortunately, how much younger the victims are getting and how much more volume of terrible materials out there. And in my research, I learned that people in the know that really understand this problem say it's not called child, it should not be called child pornography. It should be called child abuse or child sexual abuse. So this is great that you've done this. Are you, what committee are you on over in the House?
So I'm Chief of Staff for Delegate Wilson.
Oh, Delegate Wilson, and he is on what?
Government, Labor, and Elections.
Darn, because hopefully the bill that I have over there will get out, but especially if the House recognizes that the issue isn't really about pornography, but abuse. So please tell Delegate Wilson how much I applaud the bill, how much I wish I'd been a co-sponsor or a cross-file. If it doesn't pass, I'd like to be a cross-file or help him next year, and he's spot on about this. We've got to stop calling it pornography. It's nothing but abuse, and it's horrific abuse.
Thank you, Congressman.
Wouldn't you agree?
I definitely agree.
All right, thank you.
Thank you.
Thank you, Mr. Chair. And please pass on to the delegate that this is a great bill. I did want to raise something that someone emailed to us regarding the change from child pornography to child sexual abuse material. And I agree with my colleague that we should focus on what it is. But I want to read to you what this person says and get your reaction to it. And he said that quote, child pornography has historically been interpreted broadly to cover any visual depiction of minors in sexually explicit conduct. Changing it to child sexual abuse material could be read by the courts or prosecutors as excluding material that is sexually explicit or pornographic, but does not meet a stricter abuse threshold. What are your thoughts on that?
My only comment is that we're not changing the definition in statute, just the terminology. So that shouldn't be an issue in terms of those actions being in a gray area per se because of the change of the term.
Great. Thank you very much.
Thank you, Senator Love. Any other questions or concerns?
Go back to your delegate. Thank you, Senator Love. It may be smarter or just more incremental and cautious. We could say this. We could call it child pornography and child sexual abuse material, or child sexual abuse material and pornography, just in case, maybe we should get some insight from prosecutors about if there are anything about an unintended consequence. But please share with the delegate what Senator Love sort of brought up and what I'm thinking, which maybe we could combine them, just so we don't lose at all any unintended consequence that none of us maybe today can be thinking of.
That sounds great.
Do that and let us know what he thinks?
Yes, Senator, I will.
Thank you very much. Thank you, Senator Love.
But just to point out, there are at least 2 state's attorney's offices who testified favorable on this, correct?
Yes, sir.
Did they, in the testimony that they did over across the street, did they say anything about any problems that it might have changed in terminology?
No, sir.
Thank you.
Thank you.
All right. Seeing no further questions, thank you very much.
Thank you, Colin Chairman Smith.
Thanks. Have a good one.
You too, God bless.
All right, with that, that'll conclude the hearing for House Bill 1294. We'll now move on to the last bill of the day, Delegate Rosenberg, with House Bill 1320. Oh, there's no doubt about that.
Chair Smith and members of the committee, my name is Sam McGranahan. I'm Delegate Rosenberg, Chief of Staff, here to deliver sponsored testimony on House Bill 1320. Unfortunately, the delegate cannot be here today. He's doing important work over at Camden Yards right now. So, so House Bill 1320 addresses a very narrow but critical gap in victim notification timing. Current law delays notification opportunities until after indictment or information, and this is just too late to ensure victim safety. The bill ensures that victims can opt into notification at the earliest possible moment, which is during the time of charging or arrest. In the current system, there's a dangerous window where defendants are released and victims are unaware and unprepared. And that period is statistically and practically the most dangerous. Offenders may retaliate, intimidate, or re-engage with the victim in a variety of ways. So the early notice to victims allows them to secure safe housing, contact their family, seek protective orders, or any other aspects of safety and planning. Maryland already has VINE, the Victim Information and Notification Everyday system, as well as MDEC. These electronic systems are extremely capable and can be seamlessly used to solve the problem. This bill requires that law enforcement officers or district court commissioners inform victims of the VINE system at first contact and allow for immediate opt-in for notifications. This ensures that victim requests are entered into the system immediately and notifications begin as soon as custody status or changes occur. House Bill 1320 is a simple, practical fix that uses tools we already have to protect victims when they need it most. This is not about building something new. It is about using something we already have at the moment it matters most. I urge the committee to reach a favorable report on House Bill 1320.
Good job, Senator.
Thank you. I'm looking at the B2 in comparison to B1. B1 says on first contact with the victim or victim's representative, a law enforcement officer, and it goes on. But for whatever reason in this new language, it states on first contact with the victim or victim's representative in a criminal case, a law enforcement officer, and it goes on. Why Do you have any idea on why that language was included, the in a criminal case in 2 and not when it wasn't in 1?
I do not know the answer to that, but I can get back to you.
Appreciate it.
We also have an expert who might be able to help you right here.
Hey, Mr. Butler? How you doing, sir?
Come on up.
Yeah.
I got your Facebook.
Yeah, me too.
Thank you, Mr. Chairman, members of the committee. Senator Signer, the reason that it says criminal is that because Vine only works in criminal cases and not juvenile delinquency cases.
Thank you.
Thank you.
All right, seeing no further questions, thank you very much.
Thank you.
All right, with that, that'll conclude the hearing for House Bill 1320 and our hearings for the day.